Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Ashgate Publishing Limited, and it's an interesting book involving the health industry. The title of the book is Self-Determination in Healthcare. Needs to be obviously explored in a little bit more detail. There is a subtitle, A Property Approach to the Protection of Patients' Rights. It's been written by Leroy C. Edosian, and I hope I've pronounced that name correctly. I think that's it, Edosian. It's a very good book and a very thought-provoking book, I felt. It's a hardback and also available as an e-book. And my wife Elizabeth and I talked about the book and really looked at it from the point of view of what it really is about. And we've given the title of our written review, which is on the web and in the journals. Please have a look at them. We give it high star ratings because we only review books which we think are of tremendous support to practitioners, researchers and academics. The title we've given this book is Patients' Rights, a Legal and Bioethical Approach. Now, before we go into the review, let's just have a look at the book. It's got a purple cover, quite interesting. That's the front, it's a hardback. There's the spine, and then there's the back, and just some basic information. It says Leroy comes from the University of Manchester in the United Kingdom. Now, the back of the book, we'll go there first of all. It's just under 300 pages long. You can see the index. It's a reasonably detailed index, and it's actually page number indexes. Then there's a very substantial biography to be expected. Ashgate produced works of a very high quality, there's no question about that. Extremely helpful to us in practice and also as researchers. You can see in the actual book itself, it has subheadings and it has quite a lot of footnoting throughout, hence the detailed bibliography. Then at the front there are some quotes from various people, one of which is actually on the back cover as well. Then you've after that got a very nice dedication to his son there, which I like to mention. Then the front page there. Then the 10 chapters, the conclusion being the last chapter and an introduction at the beginning. So rather nice to have a bit of logic running all the way through. There's detail about the actual information about the book itself and the PDF and the ebook and so forth. There are lists of figures, and there's also a bit of detail about the writer. Then there are some acknowledgements, and there's a preface. Do read the preface, because the preface, as always, is very important. He says, I've endeavoured to provide a theoretical framework for the concepts underpinning this book, but to be mindful of the fact that this is not a treatise in philosophy or bioethics. I think that's important because I think he's trying to put forward make a particular series of points, and I think he does that very well indeed. Then there's an introduction, and you can see basically going straight into the issue of healthcare. Traditional healthcare was delivered on the basis that the doctor knew what was best for the patient, and this goes back to the Hippocratic Oath. Now you see, that's where we start off. Then we have the various chapters. Each chapter has a conclusion in it, or a series of conclusions, which are developing the particular models that he's talking about in the work itself. And then the final chapter actually is a conclusion, looking, basically wrapping everything up of the points he makes. And this is what we say about the book, because this is an area of law quite clearly, an area of activity that is going to grow. As we have an ageing population, people live longer, and a lot of advances are taking place in medicine at the moment. So we do need to look very carefully at what will become healthcare law, specifically, I'm sure, in the next few decades. This is what we say. As I said, this is a quote from the author. This book is primarily in the field of law, says the author, Leroy Edosian, but it has foundations in ethics, philosophy and the social sciences. Fundamentally then, the book explores the host of issues impinging on the matter of patient autonomy, more accurately renamed for purposes of this study as patient self-determination. And I think we know where we're coming from in terms of the much wider understanding of what self-determination means, say in political terms, or in franchise terms, or whatever it might be. In other words, you have the right to determine what you're going to do with yourself. In other words, a freedom. So that's really where we're coming from as the starting off point. The author describes himself as representing two constituencies, law and medicine. Quote, "I have tried to be faithful to both in terms of end product," he adds, "although it is always more fulfilling if the product has the potential to find practical application in clinical and legal practice." And I'm sure he's right there. You want to get a bit of satisfaction out of it. And what he's trying to put forward, I think, is a very valid series of points. The author describes patient self-determination in the following way: as the right of the competent patient to make decisions about his or her medical treatment. This concept is, of course, examined in detail in the light of legal and clinical practice based on extensive research. I would hasten to add it's also an emotive subject, as I'm sure many or anybody involved in this area will know, especially when you're dealing with family members. And so therefore that is not a word of warning, just a little observation. The book is certainly relevant in view of the increasingly entrenched scepticism among patients, rightly or wrongly, the doctor knows best. Referred to as medical paternalism, this tradition is said now to be ebbing, and for most patients this is good news. The modern approach, in contrast, places the patient at the centre of care. Here the patient is acknowledged to have a right to be involved proactively in the decisions made about his or her treatment. A breach of this right is therefore a breach of the patient's bodily integrity. An interesting observation, and I said before, with healthcare law, which is what this is going to be about, I'm sure that is going to develop in the next decades. The self-determination or autonomy of the patient is what the law seeks to protect. There are, however, obstacles. The author's opinion is that as that consent, as currently applied by the courts and by clinicians, is inadequate. Inadequate, that is, in serving its intended purpose. An alternative approach, therefore, needs to be considered. Such an approach, as indicated by the book's subtitle, is property-based. An interesting concept, I'd suggest, in its own way, which refers to the patient's body being his or her own property, which is probably the very basis of the common law, if you think certainly about tort. Certainly that would be a basic common law principle. And that the patient then in question has the right to retain ultimate decisional control over what happens to it. That is philosophically correct. Jurisprudentially, you can see there will be some arguments about how far the patient can go based on the sort of things they might want to do to their body, but that's another issue. It is suggested then that this model could provide a feasible approach for the courts to consider in cases where patient self-determination emerges as an issue. And certainly the issues of patient self-determination, consent and the property model are discussed in meticulous detail throughout this book, the preparation of which was supported and encouraged by Professor Sheila McLean, who's Emeritus Professor of Law and Ethics in Medicine at the University of Glasgow. And the author also pays tribute to Professor Robert Downey of the University of Glasgow, who's provided help in finding a roadmap for navigating this terrain. Let me conclude by saying, as relevant cases from a range of jurisdictions are discussed, this book, which is a recent title from Ashgate, should attract the interest not only, we think, of academics, but of practitioners dealing with, for example, personal injury and other medical issues with their attendant social, ethical and moral complications. And I think, therefore, as I've started off, I'll finish by saying that that's exactly why this is going to develop into, I think, a formidable area of law in its own right in perhaps the next decade or so. The publication date is cited at 2015. Let's just have one last look at the book again. There's the front of it. It's a hardback, as I say, spine, and then there's the back. As I say, there's a very good index there, and then after the index you've got a substantial bibliography, which I'll just show you. Just opening the book right in the middle. Property rights in the patient's legitimate expectations. Again, very much the sort of legal terminology we would use there. You see you've got a lot of footnoting again, and you've got just use of subheads rather than any specific numbering. You've also got quite a lot of useful examples. There's one here. Treating expectation as property endows a positive right, and that then develops through a case law study, which is quite helpful, I think, and again, more paragraph numbering. And at the front, do as I say, read the preface, which is always worth looking at to get some idea of exactly what Leroy is putting forward. Thank you again to Leroy and to all the people involved in this book, and to also, of course, Ashgate. It's a wonderful book. I didn't find it difficult to read, but it's an area which I'm sure is going to develop over the next few years. So thank you to all concerned, and watch this space for anything further happening. Bye-bye.